A review on how disputes between neighbours can be better managed, amid feedback that current processes can be exhausting. It's part of the government's plans to strengthen Singapore's legal framework. This was announced during the debate of the Law Ministry's budget.
Nearly 600 disputes between neighbours have been filed at the Community Disputes Resolution Tribunal, or CDRT, since it was set up 6 years ago. The tribunal makes orders to settle such spats. If they're ignored, an offending neighbour can be temporarily evicted. In fact, that has already happened twice. While most cases are settled within 6 months, some drag on for a year or more. So an interagency committee is now looking at how conflicts can be resolved faster and better.
For example, considering if CDRT can make interim orders, especially in cases of continuing and severe nuisance. We are also aware that some claimants can find it difficult to gather evidence to support their claims. In some cases, respondents have willfully refused to comply with CDRT's orders. In one egregious case, the respondent started to create a different type of nuisance not covered by the CDRT order, presumably to spite the claimant. We will look at how these gaps can be closed.
The committee, which involves 4 ministries, is also looking to get more unhappy neighbours to attend community mediation. More than 4 in 5 who went through this route settled the matter amicably.
Mediation is a far more sustainable, longer-term, long-lasting impact in maintaining relationship between 2 neighbours.
Also on the community justice front, the Law Ministry announced that a dedicated court for harassment cases will begin operation this year. It was first mooted 2 years ago when the government amended the Protection from Harassment Act, or POHA. There will be specially trained judges, simpler procedures, and volunteers to help victims through court processes.
We will continue to monitor the effectiveness of the 2019 amendments and will provide a more holistic assessment after the POHA court has been in operation for some time.
Since the Act came into force in 2014, the courts have received over 850 applications for protection orders. It's approved about 40% of them, with over half granted with consent from both parties. Expedited temporary orders were also granted to about 40% of applicants due to imminent danger of violence. Improving access to justice is another area the government is looking at. Hence, there'll be a new set of criteria for those seeking help under the Criminal Legal Aid Scheme. The changes will simplify the application process and reduce paperwork for applicants. Finding out more about civil legal aid will also get easier. A chatbot, which advises users on topics like divorce and personal protection orders, will soon come up with new topics. An information portal, which also advises on the types of legal assistance available, is in the works.